No, they didn't.
What's up, boy?
I've been here. Oh, yeah. We were waiting for it. Um, the judge, I call, the call that I made every week to check in, right? I don't remember, I've been on so much vacation, sorry. They, it took 3 days.
Um, which matter are you?
Collins, Your Honor.
Okay. On the record in the matter of the people of the state of Michigan versus Marcus Lamont Collins, file number is 22-03236. I can have your appearances for the record.
Brian Ring on behalf of the people practicing under Michigan Code Rule 8.120.
Jackie Moss for it, and on behalf of my client, Marcus Collins, who's standing to my right.
Okay, how are you, Mr. Collins? Okay, today's the date and the time set for a preliminary examination. I have here Nolly Cross. Says the people are unable to proceed at this time because the necessary witnesses failed to appear. And so they're moving to dismiss without prejudice. They're also objecting to destruction of records under MCL 764.26. Is that accurate?
That is correct, Your Honor.
Did the defense want to be heard on that motion at all?
No, Your Honor.
Okay, so okay, and so Mr. Collins, the court's going to grant the motion of the prosecution, dismiss this without prejudice, and order that the records be maintained under MCL 764.26. That simply means for your purposes that although the case is dismissed today, the people do have the right to reissue the charge against you if the necessary witnesses later appear and are ready to proceed. Do you understand that?
Yes,
Do you have any questions at this time? Okay, there should have been a no contact order in place. You're gonna want to wait 72 hours before you violate any of the terms of that no contact order that would include being within any exclusion zones, okay? Okay, we need to, just because we need to have time to get that out of the system. Any additional matters for the record at this time?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing on behalf of the defense, Your Honor. Thank you.
Thank you. We'll get you a copy of the dismissal and you'll be all set, okay? Thank you. Okay, we're on the record in the matter of the people of the state of Michigan versus Michael Andrew Thomas. File number 22-03269. Appearances.
Brian Ring on behalf of the people practicing under Michigan Code Rule 8.120.
Thank you, Your Honor, and good morning. Edward Hess on behalf of Mr. Thomas. Mr. Thomas stands to my right at the council table.
How are you, Mr. Thomas?
Just like Your Honor.
I'm doing pretty good. Today's the date and time that's scheduled for a preliminary examination. The people are at this time moving to dismiss without prejudice because the necessary witnesses failed to appear. They're also objecting to destruction of the records under MCL 764.26A. Any objection to that motion, Mr. Hess?
I would ask the court overrule the people's objection to the destruction of the arrest records and that those be destroyed. Other than that, of course, I have no objection to the case being.
Okay, what's the basis of the overruling?
The being arrested and being charged with a crime is quite stigmatizing. Mr. Thomas is presumed to be innocent, and as this case is being dismissed, there's been no adjudication of guilt. It's my opinion that these arrest records are prejudicial to its long-term employment and personal prospects.
I would just lose the discretion. Time, Your Honor.
Okay. Let's see.
destruction of the.
Have you had any contact with the alleged victim in this matter?
Not that I'm aware of, Your Honor.
Oh.
Or have I had any contact? Sorry, was
I meant, yeah.
No,
the
I have
prosecution's
not.
Office.
No, I have not had any contact with the victim, Your Honor. I have made a couple attempts and both the phone number that I had has been disconnected.
Oh, okay, sounds good. We have here count one, assault with intention to do great bodily harm, less than murder or by strangulation. Count two, domestic violence, third offense. There's also a habitual offender, second offense notice. Court's gonna overrule the objection as to the destruction of the arrest records. I don't think that these arrest records cause any prejudicial effect to your client. I think it's in the interest of justice, considering the fact that the people have not had any viable contact with the victim, that it's possible the victim they just don't have good contact information. They may or may not be able to reissue this charge. I don't know. But I'm going to grant the motion. The case will be dismissed without prejudice today. And that means that they have the right to reissue the charge if the necessary witness appears and is ready to proceed with this case. Do you understand that, sir? Okay. Any additional matters for the record?
Nothing bad to people. Thank you, Your Honor.
Nothing further. Thank you very much.
We're going to get you a copy of the dismissal. There was a no contact order as to April Hatfield. We were not to be within 2,000 feet of wherever she lives, works, or goes to school. You need to give us about 72 hours to get that out the system before you go within that time, that zone, or make any contact that was otherwise prohibited by that no contact order, okay? Okay, you're all set. Thank you, sir.
Thank you. Thank you very much. Sure, this is your copy. All right, good luck to you. Here you go. Very good. Thank you. You're welcome.
Thank you. Have a good one.
See you this afternoon.
Very well. See you then.
And Ms. Donnelly, who do you have with you?
I have, I'm here on behalf of Mr. Lee, for Mr. Davion Higgins.
Apartment number 8.
On the record, in the matter of the people of the state of Michigan versus Davion Markeith Edens, file number 23-00004. Council appearance.
Brian Ring on behalf of the practicing in Michigan Court Rule 8.120.
And Assistant Public Defender Sarah Donnelly on behalf of, on behalf of Mr. Assistant Public Defender John Lee, who represents Davion Higgins, who is present and standing to my right.
How are you, Mr. Edens?
Doing well. Good morning, young.
Good morning, sir. Did you get your fingerprints taken care of today?
Did I get them taken care of?
Yes.
No, I didn't.
Well, you need to get that taken care of. We'll get you taken down there after this. Today was the date and time set for a preliminary examination. I have a note here that there's a request for an adjournment.
Yes, Your Honor, I believe that the necessary witnesses are here. I'm covering again for Mr. Lee. It's my understanding that they haven't had an opportunity yet to go over the evidence in this case. We do have the medical records, we do have video. We just haven't had time to review it with him yet. Before he decides, and there's also an offer, but before he decides, he would like to have an opportunity to review that. So if we could believe that while we're within the 21 days, I would believe that maybe could cause to adjourn.
Who has not had an opportunity to review the evidence?
Mr. Lee, I believe that they had a probable cause conference last week. I'm not sure if though he had the discovery at the time, and since he has received it, it's my understanding that we still, I'm going to email the police reports and medical records, but the body worn camera needs to be provided to Mr. Eads.
Did you talk to your attorney last week?
Yes, I did.
Okay.
Via Zoom. I had a Zoom court meeting with you guys. I talked to him in a breakout very briefly. I mean, pretty much he just told me.
I don't need to hear what he told you. I just wanted to know if you spoke to him because I don't have a note that there was an issue regarding pending discovery.
I don't either, Your Honor, and it appears from my office that discovery was sent on the 6th of January.
So they were,
I'm not finding good cause. You're gonna need to have your client wait 21 days.
all right, Your Honor, are you okay with waiving your 21-day timeline so that you can review the evidence?
21 days.
Yes, you have the right to have your examination within 21 days of your arraignment date. You were arraigned back on January 1st. I have no indication here that there was some mishap with your attorney receiving discovery, and that was the purpose of last week's court date. You simply told us you wanted to continue to exam, so if there was an issue, should have advised the court or the prosecution at that time. So I don't know what's going on there. So it sounds like this is a situation where you and your attorney discuss the timeline so that you understand that you're waiving your timeline. You have your witness here today?
I do, Your Honor.
So the people were prepared to proceed today. So the defense is going to have to waive the 21 days if that's what they want to do.
All right. All right, you want to discuss that?
You guys want to discuss it?
No, do you want to wait? Do you want to waive the timeline? Okay.
Okay. Anybody threatening you to get you to waive the timeline today? Anybody forcing you to waive your 21-day timeline? Okay, we'll get you a new date to go beyond that 21-day timeline. That'll give your attorney an opportunity to review discovery with you and help you formulate a defense, okay?
I was supposed to go Wednesday, so yesterday. For getting the doctor and as well as for my review. I've kind of got.
I'm pretty sure I took you. That should have been good. Mhm. Okay, maybe it's the 10th one. Okay. All right, we'll put it on the 9th at 8:30. We'll adjourn your matter until February 9th at 8:30 in the morning. Bond was set at $5,000 personal recognizance. That will continue. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
And none for defense. Thank you, Your Honor.
Okay, can you get him down to get his fingerprints taken care of? Okay, Mr. Goodrich, are you ready on Mr. Morgan?
Yes, Your Honor.
On the record in the matter of the people of the state of Michigan versus Andres Morgan, file number 22-02343. Counsel appearance.
Thank you. Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Morgan, who is appearing from the Ingham County Jail today.
Yours clearly, Mr. Morgan.
Good morning, Your Honor.
Good morning. Today was the date and time set for sentencing. I do not have an updated pre-sentence report. The last report that I have was dated for October 12, 2022, when Mr. Morgan failed to appear to probation to complete the packet. I do, however, have a report from Community Mental Health from November 16th. Do you have that, Mr. Goodrich?
Yes, I have both of those reports, Your Honor.
Okay. And I do see where he was ordered by the magistrate to undergo this evaluation. Let's see. He pled guilty back on September 15th to an added count of use of methamphetamine. You can proceed with allocution.
Thank you, Your Honor. Your Honor, Mr. Morgan certainly has had an issue with drugs, which is why he was in front of the court in this case to begin with. After he missed that sentencing date, he ended up picking up a new felony case, which is currently pending in front of Judge Dragonchuk. He has been in jail now since November 14th, since picking up that new case. I believe he's entitled to 75 days of credit on this file. We would ask the court to consider sentencing him just to time served at this point, considering the amount of days he has done and the fact that he's not going to really be able to do probation going forward as he's incarcerated. And I think it's likely that he will end up doing some type of probation with Judge Dragonchuk in a resolution of the felony file moving forward, Your Honor. Thank you.
What is he being held on?
Both this file and the felony home invasion case. I think the felony home invasion looks like he has a 10,000 cash or surety bond on that case.
Okay, I will credit him 75 days served. On this file. And close the file. Any additional matters for the record?
No, Your Honor. Thank you.
Okay, you're all set, sir.
Thank you. Have a great day, Your Highness.
Same to you, sir.
All right. Thank you, Your Honor.
Thank you.
Have a good day, Mr. Rich.
Thank you.
Yeah, bye.
Mr. Starks, which matter are you here on? Oh, Harrison refused to come.
Good morning, Your Honor. I'm here on,
I think you're here on Harrison, correct?
correct, yeah.
This was just set for review. Don't have anything, any updated information.
Your Honor, it's my understanding that they're still waiting on bed space for him at CFP.
Okay.
He's still in Ingham County, and Mr. Bigelow tried to reach out to the jail this morning. He's refusing to participate in today's proceedings again.
Okay, sounds good. We're gonna reset the review hearing. How long is it gonna take for them to get some bed space? No idea. Let's do 60 days. We're resetting Harrison's review. I'm taking that day off. Taking that day off too. No, it's like Friday, March 31st. At what time? Correct. I mean, I know I got here at 8:30 today, but let's not get carried away. At 9 a.m., thank you.
Take the credit, Jeff.
Friday, March 31st at 9 a.m. We'll reset. Hopefully by then, we'll get some positive information on this file.
Thank you, Your Honor.
Thank you. Have a good one. be seated. Is Adina Lopez here?
She's here, Your Honor.
Okay. sounds good. Record in the matter, the people of the state of Michigan versus Patrice Jackson. This is file number 20-01605 FY. Council appearance.
Brian Ring on behalf of the people practicing under Michigan Court Rule 8.120.
Thank you, Your Honor, and good morning. Jared Austin, appearing on behalf of Patrice Jackson. She appears with us today remotely from the Ingham County Jail.
Ms. Jackson, can you hear me clearly, ma'am?
Yes, I can, ma'am. How are you?
I'm doing well. How about yourself?
I'm doing okay. Thank you for asking.
No problem. Today is the date, ma'am, that was set for you to have a preliminary examination. My understanding is that there is a plea offer. The offer from the people is for you to plead guilty to an added count 2 of use of a controlled substance under Michigan Compile Law 333.74042B. Is that accurate? Am I reading that accurately?
3337404 that's correct, Your Honor.
Okay, thank you. That's a misdemeanor maximum penalty, 1 year and or $1,000 in fines. The people are willing to dismiss count 1 upon successful plea to count 2, and they're not objecting to sentencing under 7411 if eligible. Is that a complete and accurate understanding of the plea offer?
That is my understanding of it, Your Honor, yes.
Okay, and that's your understanding as well, Ms. Jackson?
Yes, ma'am.
Do you want to accept that offer today?
Yes, I do.
Okay, let me have you raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, I do.
Okay, you can put your hand down, ma'am. In this matter, you have the following rights. You have the right to proceed to trial, and you have the right to have a jury trial, or you can have a non-jury trial. At the time of trial, ma'am, you have the right to the presumption of innocence. So that means that you are considered innocent until the prosecution can prove you guilty. Do you understand that?
Yes, I do.
You have the right, ma'am, to have the prosecution prove each element of the charge being brought against you beyond a reasonable doubt before you are considered guilty. Do you understand that?
Yes, I do.
And you want to waive those rights today in order to enter a guilty plea to the added count of use of a controlled substance?
Yes, I do.
Okay, so that means that you're also going to have to give up your right to cross-examine any of the witnesses that the prosecution intends to call. You're going to give up your right to call your own witnesses to trial or present evidence that you believe will further defense to this charge. You're also going to give up your right to remain silent at trial and not have silence be used against you. Do you understand that?
Yes.
Okay, you want to give up those rights?
Yes, I do.
Okay, anybody making any threats to you to get you to waive your rights and plead guilty?
No.
Has there been any promises to you in exchange for you entering a guilty plea to the amended charge?
No.
Are you currently on probation or parole?
Probation?
Okay, what are you on probation for, ma'am?
Well, I don't know that I am. Well, yeah, I am with Miss Anger.
May I speak to that, Your Honor?
Yes,
She
please.
was on probation at the 55th District Court. It appears that recently that may have been terminated because it seems that she's serving a sentence on that until February the 16th. So she may have been on probation, but it appears she no longer is.
Okay. And that was for 55th?
Correct.
Okay. So she's not being held on anything else other than this, and then she's serving time on the 55th matter?
Correct. I think she does have some pending city matters, Your Honor. She may have bonds on that she has posted, but other than that, I think that's the only sentence that she's currently under.
Okay, sounds good. Ms. Jackson, do you understand that a guilty plea could result in a conviction that may violate any status that you may have on probation if you are still on probation?
Yes,
Okay, you understand that a guilty plea can result in a conviction that may need to be reported to a future job or placed on a job application?
yes,
You also understand that a guilty plea can result in a conviction that may have impact on any immigration or travel status that you may be seeking, like you may want to travel to Canada, and that could impact that ability to do so. You understand that?
yes,
Okay, you still want to waive your rights?
yes, I do.
Okay, and this is a matter that has a sentencing penalty maximum 1 year and or $1,000 in fines. Although there is a request or a no objection, I should say, to sentencing under special status 7411. There's no promise that you're going to get that. Do you understand that?
Yes, I do.
Okay, as to the added count 2 of use of a controlled substance, how do you plead?
Guilty, Your Honor.
May I have a factual basis, counsel?
Yes, Your Honor. Ms. Jackson, I want to take you back to December the 27th of 2019. Is it true you were at or near the location of 1415 Kalamazoo Street in Lansing, Michigan?
Yes, it is true.
Is that here in Ingham County?
Yes, sir, that's true.
And at that date, time, and location, is it true that you had on your person the controlled substance known as cocaine?
Yes, I intended to consume it.
Yes, and that was amount that you was for your own personal use, is that correct?
Correct.
Satisfied, Your Honor?
Any questions from the prosecution?
Just one. And Ms. Jackson, you knew that substance to be cocaine, correct?
Yes,
No further question.
Thank you. The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Sentencing is going to be March 31st, 2023 at 8:30 in the morning. Prior to sentencing, ma'am, I'm ordering that you undergo an evaluation for substance abuse, and you will meet with our probation department so they can provide the court with a pre-sentence report and recommendation as to how you are to be sentenced. Do you have any questions about that at this time?
no, Your Honor.
Okay. Any additional matters for the record, counsel?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing further on behalf of Ms. Jackson, Your Honor. Thank you.
Okay, thank you, Ms. Jackson. You're all set.
Thank you. You guys have a nice day.
Same to you, ma'am. Okay. We're on the record in the matter of the people of the state of Michigan versus Davina Lucia Lopez, file number 22-03530. Counsel appearance.
Brian Ring on behalf of the people practicing under Michigan Court Rule 8.120.
Good morning, Your Honor. Jared Austin appearing on behalf of Ms. Lopez. She stands present to my right.
How are you, Ms. Lopez?
Good, ma'am.
Did I see you already this week?
Yes, you did.
Okay, today was the date and time set for a preliminary examination. I also have here a PA 53 violation that you need to be arraigned on.
Check that one more time.
Yeah, to the violation, I have a police report here, case number 23519000419. Report date was for January 12th, 2023 at approximately 1600 hours in the area of 5510 K North Road, City of Lansing, Ingham County, State of Michigan. There's an allegation, ma'am, that you violated the terms of your conditional release from custody, that being a no contact order, by making a contact directly or indirectly with the alleged victim in this matter, Jaden Noel Pavona.
Your Honor, that is not the same victim that is on this file.
That's what I see. Let's see here. Well, the allegation, however, would still be a bond violation. Is an allegation that you allegedly sent a photo of a gun to Pavona and made contact with them through Facebook. It appears, it says Pavona stated they already had a police report for telephone harassment. I don't know if there's another case pending with that person as a victim. Definitely not the same person in this case. However, there was a bond condition that the defendant was not to be in possession of a firearm. It was also a bond condition that the defendant was not to engage in any threatening behavior or assaultive behavior on bond. So whether it's the same victim or not, this is still considered a PA 53 violation. So you have the right to have a contested hearing. You have the right to be represented by counsel on that contested hearing. If you are found to be in violation of your bond conditions, that's a violation of the court's order, which is a contempt order, and that is punishable with the maximum penalty of 93 days and or $7,500 in fines. You also could be remanded to the custody of jail pending your matter before this court. Do you understand that?
Yes, I do.
Okay. Counsel, how would your client like to plead as to the violation?
Yes, Your Honor, may I have just one moment briefly, please?
Please take your time. Yes, sir. Which victim? Last name Pavone? Pavone. That's on this one too, but that's not what the issue is. They're saying the victim's name is Jaden Pavona. We understand. I don't know what that means.
Traffic ticket. Yeah, okay.
Your Honor, may counsel approach?
You may. Okay, so at this time, this matter is going to be reset. I don't believe that the necessary witness has appeared. However, Ms. Lopez, you were almost an hour late for court today.
Yes.
I didn't ask
Oh, sorry.
for an excuse. You were almost an hour late for court. Court is set for a time for a reason. And in addition to that, I want to subpoena the officers in here to address the allegation of the no contact order violation, or the violation of the bond, I should say, because I don't think it was a no contact order. Because this victim is not a victim that was named in this file or any pending file before this court. But I do have concerns about the allegation of the use of a firearm and some threats of assaultive behavior. So the court's going to keep this file open. In order to address that, we're going to set this for a hearing for the PA 53 violation, and I'm going to reset the preliminary examination for the same date and time. Did you want to say something at this time, ma'am?
So tomorrow?
No, it won't be tomorrow.
Oh, okay, no, that's fine. Not Monday either?
It definitely won't be Monday either.
All right.
Sounds like you have plans.
Yeah.
Okay, okay. Well,
Well, Horton, he is Fort Mason. Yeah.
okay, yep, it won't be that quick. But we'll get you the date and time right now. I'm sorry? What's the date? That's Friday, works for me. Okay, Friday, January 27th at 8:30. Any additional matters for the record?
Nothing on behalf of people. Thank you, Your Honor.
Nothing on behalf of Ms. Lopez, Your Honor. Thank you.
Okay, Ms. Lopez, I'm gonna reiterate your bond conditions. Primarily because the date of the allegations of the bond violations took place the same date that you were in court on this underlying matter for a probable cause conference. You were arraigned on this matter by by Magistrate Melmore back on January 3rd. He issued the following conditions. One, there was a no contact order between you and the alleged victim in this matter, which is a Nancy Oride. But there was also the orders that you were to not engage in any assaultive or threatening behavior, that you were not to possess or purchase a firearm or any other dangerous weapon. You understand that? There's also an order that you are not to use, purchase, or possess marijuana or any other controlled substance without a valid prescription. You're not to travel outside the state without prior approval of the court. Do you have any questions or concerns or confusion about your bond conditions?
It was so you can't text, basically, that's what you're saying? So like if you're in an argument, you can't text.
No, no one said you can't text, but you can't threaten people in your text, because that's would be engaging in assaultive or threatening behavior. Oh,
All right, yeah. So
Got
even
it.
if they say something.
yeah, it's like you should be on your best behavior. And you should have like extra self-control.
Yeah,
That's what that means.
I just deleted my Facebook. I'm getting better.
Okay, that sounds like a good idea. But it's up to you how you want to proceed with your social media, but you're not to engage in any threatening behavior. You got some pending matters and you don't want anybody to think that you're threatening them. So do you have any other confusion about the bond conditions?
No, you answered it.
Okay, very good. Any additional matters for the record?
Nothing on behalf of people. Thank you, Your Honor.
Nothing on behalf of Ms. Lopez, Your Honor. Thank you.
Thank you. You're all set, ma'am.
Thanks.
Thank you. Okay. Who's this back here?
Your Honor, and that's a plea we started by video last week, and she had trouble hearing because she had hearing aid.
Okay, very good. She took care of her fingerprints as well?
Excuse me, Honor,
Did she get fingerprinted?
I don't know, have you been fingerprinted yet, Ms. Carr?
I'm sorry, say it again.
Have you been fingerprinted yet?
No, they told me that they were busy to go to work and then go down there.
They said they were what?
They told me to come to court first and then go down there.
Okay, sounds good. All right, you're ready. We're on the record in the matter of the people of the state of Michigan versus Akia Denise Carr, file number 22-03526. Council appearance.
Brian Ring on behalf of the Pricing of Michigan Court Rule 8.122.
Attorney Derek Etch, also public defender on behalf of Ms. Carr. Ms. Carr is standing to my left.
Very good. Ms. Carr, can you hear me?
Yes, but do you have like a, you know how you have like a
The
mic?
device?
Yeah, device.
We do. Hopefully it works. We'll go off the record so we can get that for her,
Thank you, Honor.
because I might need Mr. Bigelow to assist and scale with that.
Only because like my ear and I can only hear when you're like right next to me, like in front of me.
Sounds good. I don't know if that works, because it's always an issue, but we'll see. You can have a seat.
Might as well look at it and see if I can figure it out.
I'm glad that they make it user friendly.
It's better than the one, we used to have a different system, and that had to be plugged into the recording software. You had to physically connect it to the thing.
Can you hear us?
Can you hear me?
Yes.
Very good. Okay, we're back on the record in the matter of the people of the state of Michigan versus Akia Carr. Today was the date and the time set for a plea. We attempted to do the plea last week. I did have concerns about her ability to understand the proceedings. And so I ordered her to appear in person. The offer might be up too loud. Okay, there we go. Is she too close to the mic, maybe? Can you back up a little bit?
Yes.
Okay, that might be better. Okay, the offer from the people, ma'am, was for you to plead guilty to added count 2 of use of a controlled substance under Michigan Compile Law 333.74042B. That's a misdemeanor. Maximum penalty is 1 year and or $1,000 in fines. Do you understand that to be your offer, ma'am?
Yes, ma'am.
And do you want to accept it at this time? Wanna-
Sorry, repeat yourself.
Do you want to accept that offer and plead guilty
Yes.
today? Okay, please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
You can put your hand down.
Your Honor, regarding the offer, there was agreement to no upfront jail and no objection to 7411 as well. if I recall.
Okay, that is correct. It's noted here. There's a Killer Brew agreement. That's an agreement between you and the prosecution that you will not be sentenced to jail. Do you remember that to be a part of your plea agreement?
Yes.
Okay, so I'm going to advise you that, again, that's an agreement between you and the prosecution. I'm not a party to that agreement, and I'm the one who will be sentencing you. Do you understand that?
Yes.
So that means that at the time of sentencing, if I find a reason to put you in a jail, I will then give you your right to withdraw your plea offer, okay?
Yes, ma'am.
And then 7411 status, there's no objection to that. We'll address that once we know if you're eligible for that, okay?
Yes, ma'am.
Okay. I have here an advice of rights and plea information sheet. Did you go over these rights with your attorney?
Yes.
Okay, do you have any questions about these rights?
No, no.
Okay, you understand that you're giving up your right to have a trial in this matter if you plead guilty?
Yes.
You understand that you would be giving up your right to the presumption of innocence. So that means as you stand here right now, you're considered innocent and it's up to the prosecution to prove you to be guilty. You understand that?
Yes, ma'am.
And you understand that they have to prove your guilt beyond a reasonable doubt. You understand that?
Yes, ma'am.
And so they would have to prove each element of the charge that they're bringing against you, and you don't have any burden to prove anything or to prove your innocence. Do you understand that?
Yes, ma'am.
You want to give up that right today?
Yes, ma'am.
Okay, so that means you're also going to give up your right to see, hear, or question any of the witnesses that they intended to call against you. You're going to give up your right to call your own witnesses to a trial or present evidence at trial that you believe would show a defense to the charge that they're bringing against you. Do you understand that?
Yes, ma'am.
Okay. You're also going to give up your right to remain silent at trial and not have silence be used to imply or prove that you're guilty. You understand you're giving that right up as well.
Yes, ma'am.
Anybody threatening you to get you to waive your rights and plead guilty?
No, ma'am.
Has there been any promises made to you not stated here on the record to get you to waive your rights?
No, ma'am.
Okay, you understand that a guilty plea can result in a conviction that may have impact on any travel or immigration status you may be seeking.
Yes, ma'am.
Also, a guilty plea can result in a conviction that you may need to report to your current employer. Do you understand that?
Yes, ma'am.
You may also need to put that you have a criminal conviction on a future job application. Do you understand that?
Yes, ma'am.
Are you pleading guilty because you believe you're guilty?
Yes, ma'am.
Okay, as to the added count to abuse of a controlled substance, how do you plead? Guilty, not guilty, or do you stand mute?
Okay.
Factual basis.
Thank you, Your Honor. Ms. Carr, drawing your attention to 4/6/2022, were you at 707 McKim Avenue, City of Lansing, Ingham County, State of Michigan? You're at that address.
It's like 2205 or 707?
707, can you hear
Yes.
me?
Mhm.
Okay, so try to listen to me now. Listen so you can hear me. So you were at that address on April 6, 2022, correct?
Yes.
And at that time, you knowingly and intentionally possessed some heroin, correct?
Yes.
And you knew it was heroin, correct?
Yes.
And you didn't have prescription for it, correct?
No, I didn't.
And your intent at that time was to use it, correct?
Yes.
Thank you.
Any questions from the prosecution?
Husband Bill, thank you, Your Honor.
The court is satisfied with the factual basis. I will accept your plea. Find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Sentencing is going to be March 31st at 8:30 in the morning, and that can be held. Actually, I'm going to have you hold it in person because I want you to use the device, okay?
Yes.
So you'll come back here in person for your sentencing. When you leave here today, two things you're going to need to do. You're going to need to go down back to get your fingerprints taken care of, okay?
Yes, ma'am.
You need to go to the 5th floor, which is where the probation department is. They're gonna get you set up for your pre-sentence report and investigation. There's paperwork you're gonna need to complete. I'm also gonna order that you undergo a substance abuse assessment, okay?
Your Honor, regarding the assessment, it's my understanding you're getting services through CPS, so they may have done an assessment and she could sign a waiver for them to get updated information about the assessment current testing.
I'll note that here in the file, and if that's the case, then probation will be able to get that.
Thank you. Do you have a question for me?
Okay, so do you understand what you're gonna do when you leave here today?
Yes, ma'am.
Do you have any questions for the court?
No, ma'am.
Any additional matters for the record, counsel?
Nothing on behalf of the people. Thank you, Your Honor.
No, Your Honor, thank you.
Thank you, Ms. Carr, you're all set for today.
Thank you.
On the record, in the matter of the people of the state of Michigan versus Timothy Jacob McGovern, file number 22-03262 FY, counsel appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Morning, Your Honor. Derek Getzler from Wells Fargo defender on behalf of Mr. McGovern. Mr. Governor standing to my left.
How are you, Mr. McGovern? Today's the date and the time set for a preliminary examination. How are we proceeding?
Your Honor, today there's going to be an adjournment request by both parties as well as a waiver of 21 days.
Okay, what is the purpose of the request for the adjournment?
Twofold. First, I spoke with the victim yesterday. She, after playing phone tag for a while, she never received her subpoena, so she did not know about the hearing date today. I have an email address, which means we'll be able to do e-service in the future, so she actually gets the subpoena. Secondly, there was new evidence discovered, created 2 days ago, and that was provided to defense counsel yesterday. Frankly, it's a jail call that needs to be cleaned up and a clearer version to be produced, which I can make with the secure system. It just takes some time, as there are differing interpretations currently as something that was said that could drastically impact how this case moves forward. And so as a result of that, the defense and myself will both request adjournment in this matter.
Mr. Etheridge?
That's correct, Your Honor. I discussed this with Mr. McGovern yesterday by Polycom and went over all that was said by the prosecutor, and he agrees and believes it's in his best interest.
Okay, based on the information provided today, the court's going to find good cause to go beyond the original timeline set. So for your information, Mr. McGovern, you did have the right to have a preliminary examination in this matter within 21 days of the date that you were arraigned. You were arraigned on this matter on January 5th due to both the lack of service or subpoena to the complaining witness, as well as the new evidence that is being cleaned up at this time. The court believed that it's in your interest and in the interest of justice to adjourn this beyond the 21-day timeline so that you can have that information reviewed by your attorney, and they can have time to help formulate any defense if necessary. Okay, sir?
Yes.
So we're going to get you a new court date. Do you have any questions at this time?
No.
Does that make it anything?
I'm sorry?
Am I supposed to be getting your date, or is?
Nobody else did.
Oh, I can't see over there. I'm sorry.
Oh, yeah. No, he's not in here.
And I'm sorry, how far out were you looking to move that?
At least a couple of weeks.
Couple of weeks? Middle of February, February the 16th or February the 24th?
February 16th works.
February 16th at 8:30.
Either one works. I have the potential for search for a trial for either date. If that happens, I'll have someone from my unit covered.
Okay, February 16th at what time?
Oh, pardon me?
What time?
8:30?
February 16th at 8:30. Any additional matters for the record today?
Not from the people, Your Honor.
No, Your Honor, thank you.
Thank you. You're all set for today, Mr. McGovern. Notice to appear? Yes, but she can print it. Thank you. And then Mr. Clark is in custody.
Yes, Your Honor, and that will be an adjournment of the preliminary exam. There's an offer to have him screened for drug court, so that he's accepted that.
Sounds good. And I thought I saw Mr. Austin, but maybe not.
Yeah, he's here. He has a.
He was just there and then I looked up and he was gone.
His stuff is still here.
We're gonna run Mr. Jackson.
Unfortunately, I can't currently ignore everybody else. I have to do a little differently. I have your notes for Mr. McGovern.
Carlos Clark. Yes, please. And then, Mr. Austin, are they still running Melvin Jackson? Are we running Jackson?
He's apparently not here, Your Honor.
No way.
According to Mr. Ross, he is not here. My trooper is here. The one day my trooper's here, and I don't have to adjourn. I'll go grab Mr. Austin real quick. Sorry. Yeah, for Jackson.
Okay, we're on the record in the matter of the people of the state of Michigan versus Melvin John Jackson, file number 22-03249 FY, council appearance.
Brian Ring on behalf of the people practicing under Michigan Code 8.120.
Good morning, Your Honor. Jared Austin appearing on behalf of and in the absence of Melvin Jackson.
Okay, today was the date and time set for an exam. We reset this multiple times due to the trooper's inability to be here. I think there was a family medical issue. My understanding is that we have the trooper today, but I'm not sure if your client is here.
I have not seen him yet, Your Honor, which has certainly been unusual considering the pattern he set for himself. He has always appeared. He has appeared in person and timely for each and every court date. I have not heard anything from him this morning indicating where he's at or why he is not here, but he has always appeared timely in the past.
Have you made contact with him today or attempted to make contact?
I was just getting ready to make a phone call to him.
Okay.
If I may have the opportunity
Absolutely.
to do that, so I can at least maybe ascertain his whereabouts.
Sounds good. Works for me. We're off the record.
Thank you, Judge.
And then we'll bring Carlos Clark up and that's all the exams will have. Exams today. when you're ready. Yep, thank you very much. Mr. Clark?
Yes.
Okay. Well, on the record, in the matter of the people of the state of Michigan versus Carlos Clark, file number is 22-01749 FY. Council appearance.
Brian Ring on behalf of Teal practicing under Michigan Code Rule 8.120.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Carlos Clark, who is present and standing to my right.
How are you today, Mr. Clark?
Good.
Okay, today's the date and the time that was set for a preliminary examination. I have a note here that there's a request to adjourn. It's going to be screened for drug court, is that correct?
Yes, Your Honor.
Has he been screened before?
He is not, Your Honor. When initially that was the offer for drug court, but Mr. Clark didn't appear for his preliminary exams. So we haven't had the opportunity to get him screened yet.
Okay. Well, due to the age of the case, we don't need to address the timeline on this matter. I will note that he's going to be screened for drug court. And we'll reset this matter 30 days out.
We can do February 24th at 10 a.m.
Okay, this matter will be adjourned until February 24th at 10 o'clock in the morning. Bond in this matter was set at 2,000 cash surety. That will continue. Any additional matters for the record?
Nothing on battlefield, thank you, Your Honor.
And none for defense. Thank you, Your Honor.
You're all set for today, Mr. Clark. Any luck on your client?
Yes, Your Honor, I did reach Mr. Jackson. He told me that he is on his way. He mistakenly thought the court was tomorrow on Friday, so that's why he.
No, I'm gonna give him some grace because I thought today was Friday when I woke up. So it happens. We'll wait. No problem.